Virtual Lesson 4.2 The Government and the Workplace. The Beginnings of Government Intervention. Prior to Confederation, governments generally did not feel the need to enact legislation to regulate the workplace. Workers were seen as self-reliant individuals who had every opportunity to find satisfactory employment on farms or elsewhere in their rural communities. By the 1870s, however, Canada's shift from a pre-industrial society to a capitalist industrial society was underway. Urbanization was taking place, with many workers moving from rural areas to the cities to find employment as unskilled factory workers. This created a power imbalance, largely due to the fact that such workers were easily replaceable. They were therefore not highly respected as individuals and were vulnerable to abuse by their employers. The first intervention by the governments occurred in the 1880s, when the Ontario and Quebec governments introduced legislation that prohibited child labor, boys under 12 and girls under 14, in factories with more than 5 employees. Although this was an important first step in protecting workers' rights, the child labor laws were difficult to enforce. The next pressing need was the protection of minors who were working in very dangerous conditions, and by the early 1900s, all provinces had passed laws to do so. In 1915, Ontario introduced its first workers' compensation legislation that required injured workers to be compensated in predetermined amounts by employers in exchange for giving up their right to sue. By the mid-1930s, most of the other provinces had enacted similar legislation. Early regulation of employment standards. Economies all over the world were suffering during the Great Depression, which began in 1929. Canadian governments were influenced by the writings of the British economist John Maynard Keynes and the New Deal policies of American President Franklin Delano Roosevelt, which both proposed a greater level of government intervention in the economy. In 1935, Ontario enacted the Industrial Standards Act in an effort to eliminate sweatshops by setting minimum wages and work standards, such as a maximum number of hours at work per week. World War II brought an end to the Great Depression, and employee unions found that they had more bargaining power and started to fight for even higher wages, smaller number of hours, and better working conditions. The Second World War also marked the point when women started entering the workforce in increasing numbers. This required additional legislation to deal with issues such as pay equity and pregnancy leave. Current employment standards legislation. Today, there is legislation at the federal level and in all the provinces to govern working conditions and employer-employee relations. The Canada Labour Code, first enacted in 1967, covers employees of the federal government and private sector industries that operate interprovincially or internationally, such as railways, telecommunications, ferries, tunnels, bridges and canals, banks, uranium mining and processing, and federal crown corporations. The Ontario Employment Standards Act, or ESA, first enacted in 1968, is the most comprehensive employment standards legislation in Ontario. It applies to employer-employee relations where the work is performed entirely or mainly in Ontario. The legislative history of employment standards in Ontario. 1884. The Ontario Factories Act set minimum age and maximum hours of work for boys and girls. 1920. The Minimum Wage Act set minimum wage for female employees. 1922. The 1 Day's Rest in 7 Act provided for at least 24 consecutive hours of rest in each 7-day period, applied with exceptions to hotels, restaurants, and cafes in cities. 1935. The Industrial Standards Act set industry-wide maximum hours of work for industries. 1936. The Factory, Shop, and Office Building Act is enacted. The term home worker was defined to ensure minimum employment standards for these workers. 1944. The Hours of Work and Vacations with Pay Act set minimum annual vacation time and vacation pay. 1968. The Employment Standards Act set 8-hour day and 48-hour work week and brought together other minimum employment standards with one act. 1970. The Women's Equal Employment Opportunity Act provided leave of absence without pay for women prior to and after pregnancy. 1988. The Pay Equity Act promoted pay equity with consideration of male-dominated and female-dominated job classes. 1990. Amendments to the Employment Standards Act extended pregnancy leave to 17 weeks and introduced parental leave. 2001. Amendments to the Employment Standards Act introduced emergency leave, reprisal provisions, and written agreements that may vary employment standards. The objectives of employment standards legislation. Employment standards are meant to even the imbalance of power that would otherwise exist between employers and employees. Because of the facts that employers are fewer in number than employees, and that they are more flexible and have more options to ensure success, it would be possible for employers to foist unconscionable terms on employees who are desperate to find work. The only exception to this imbalance would be the rare case of a labor shortage, during which individual employees would have a stronger bargaining position. Employee standards legislation creates inalienable rights, meaning rights that cannot be surrendered or transferred. So, for example, no matter how much an employer is willing to pay, an employee cannot surrender their right to vacation time. The aspects of employment listed below are covered by most employment standards legislation. In Ontario, they are contained in the Employment Standards Act. The standards set are minimum requirements. Higher standards may be offered or negotiated either individually or collectively by labor unions. The minimum requirements include regular and overtime hours and overtime compensation, minimum wages, time off or premium pay for public holidays, breaks during shifts, minimum time off between shifts and per week, vacation with pay, pay equity between men and women for work of equal value, non-discriminatory eligibility for benefits, pregnancy and parental leave, continuity of employment even after restructuring, severance pay upon termination, the right to refuse unsafe work, and the prohibition of lie detector tests for employees. Enforcing the law. Government inspectors will conduct investigations into known breaches of employment standards, sometimes in response to complaints and sometimes on their own accord. Many of the issues then need to be resolved in a court or tribunal, which is a judicial panel with the authority to make decisions in a specific area. Tribunals are typically less formal than courts, following more relaxed rules of evidence with the goals of determining truth in a relatively quick and inexpensive manner. In some cases, the enforcement of employment standards is challenging, especially when the work is conducted in a secretive manner and the employees are unaware of their rights. For example, some people are home workers, being paid for manufacturing on a per-item basis. They would have little opportunity to discuss their situations and learn about their rights to a minimum wage and vacation pay. Safety in the workplace. Protecting workers is extremely important. Approximately 1 million employees are injured on the job every year in Canada, and there are fatalities almost every day. The most vulnerable group is young workers, between the ages of 15 and 24, who may also be the group who are least equipped to advocate for themselves with respect to safety concerns. The Safe Communities Foundation was established by Paul Kells in 1996 after he lost his son Sean to a workplace accident. Its purpose was to educate and assist communities in adopting safer work practices in order to minimize the occurrence of injuries and deaths on the job. In 2012, Safe Communities joined with Safe Kids Canada, Smart Risk, and Think First Canada to form a national charitable organization called Parachute. Most provincial governments have adopted the position that the responsibility for workplace safety needs to be shared between the employer and the employee. In Ontario, workplace safety is governed primarily by the Occupational Health and Safety Act, in force since 1979, and its regulations. Each workplace is responsible for creating an internal responsibility system, or IRS, consisting of either a single health and safety representative or, for larger employers, a joint health and safety committee that works with both the employees and management to identify and protect workers against risks. The Ontario Ministry of Labour would then intervene only when necessary to conduct inspections or resolve disputes that could not be handled by the IRS. The government is also responsible for collecting and providing data on workplace injury rates and on the harmful effects of dangerous chemicals and substances. In addition, the Ministry of Labour assists in the enforcement of the Occupational Health and Safety Act by imposing fines when its provisions are breached. Compensation. Each province in Canada has established its own workers' compensation program to cover expenses for employees who have been injured or become sick due to conditions in the workplace. These are insurance programs that are primarily funded by employers. The underlying principle is that the employee has taken risks on behalf of the employer, so the employer should take responsibility by compensating the employee or their dependents or survivors. The size of the premiums that employers must pay on behalf of each employee generally depends upon the specific risks involved in the industry, as well as the track record of the employer. The possibility of reduced premiums acts as an incentive for employers to keep injury rates low. In Ontario, claims for compensation are submitted to the Workplace Safety and Insurance Board, or WSIB, which then conducts an investigation and acts as an intermediary between the employer and employee as the claim is sorted out. If claims are disputed, the WSIB may also act as a mediator to help the two sides agree to a set of facts and negotiate terms. If a party is unhappy with the decision of the board, they generally have a right to appeal. Workers' compensation programs also provide a measure of certainty and predictability when dealing with injuries to employees. For one thing, workers generally give up their right to sue in exchange for protection under the programs. This means that an employer doesn't have to worry about having to pay any surprisingly large judgments awarded by the courts. In addition, workers' compensation legislation helps promote continuity for both the employee and the employer by requiring the employer to reinstate workers wherever possible, and by requiring employees to return to work when they are able. Finally, workers' compensation boards also play a role in funding safety research, education, and training, as well as agencies that provide rehabilitative care. One interesting issue related to safety in the workplace is that of alcohol and drug testing. This is fairly common in the workplace in the United States, but is currently illegal in Canada. The proponents of this practice argue that alcohol and drug abuse on the job can lead to serious accidents that cause both injury and expense to the workers' compensation system. Critics of the policy view it as an invasion of privacy and possibly discriminatory against those struggling with mental disabilities such as addiction. Freedom from discrimination. At the federal level, freedom from discrimination is guaranteed by the Canadian Charter of Rights and Freedoms, and at the provincial level in Ontario, it is guaranteed under the Human Rights Code. Discrimination is prohibited in the province on the grounds of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, age, record of offenses, marital status, same-sex partnership status, family status, or disability. Some cases of discrimination are obvious, but many are more difficult to identify because they are subtle, indirect, or unintentional. For example, an application process requiring an English proficiency test may be discriminatory against new immigrants, and a job posting that is too specific in its description of ideal candidates may discriminate by discouraging people of certain ages, body types, or lifestyles. In addition to discrimination in hiring, the Code prohibits on-the-job harassment and the practice of limiting membership in a vocational association based on the same listed grounds. The Code also establishes the Human Rights Commission for the purposes of considering and adjudicating complaints. As a tribunal, it has the power to make orders that are binding on both public and private sector employers. Women in the workforce, proving themselves worthy. Prior to World War II, very few women worked outside of the home. During the war, however, the shortage of male laborers and the increased demand for manufacturing created both the need and the opportunity for women to enter the workforce. They quickly proved themselves to be as capable as men in all types of jobs, and their contributions were critical to the war effort. Their advances were short-lived, though, since after the war ended in 1945, the returning soldiers and the heightened public sentiment toward traditional family values caused most of the working women to return to their roles as homemakers. Demanding equality. It was not until the late 1960s and the formation of the women's liberation movement that the collective voices of women started to demand their rightful places in the workforce, and increasing numbers of them started to return to work. This powerful movement demanded social and legal changes, which led to the federal government creating the Royal Commission on the Status of Women. Among its recommendations was the creation of Status of Women Canada in 1971, which is a federal ministry dedicated to the goals of gender equality and the full participation of women in Canadian society. In the years that followed, a number of significant legislative changes were made, which still to this day help to ensure the rights of women in the face of ongoing discrimination. Gender pay equity. It is now clearly illegal to discriminate against women by paying them less than men when performing the exact same job. Pay equity is still a challenge, however, due to the fact that many specific types of work are either male or female dominated. If a female-dominated type of work is paid less than a different but equivalent male-dominated type of work, this creates systemic discrimination, which may be hard to identify. The Ontario Pay Equity Act, in force since 1988, has been put in place to address this problem by requiring all public sector employers and private sector employers with 10 or more employees to assess and compare both male and female-dominated types of work and to provide equal pay for work of equal value. Comparison of the legislation. In Ontario, the Employment Standards Act, the Pay Equity Act, and the Human Rights Code all deal with discrimination in the workplace, but there are subtle differences. The Employment Standards Act specifically requires equal rates of pay, in other words, monetary compensation. The Pay Equity Act covers all forms of compensation for work, including pay and benefits. And the Human Rights Code requires equal treatment in general in relation to employment.